Good morning, everyone. So it's been peaks and valleys since COVID. And of course, last Friday was no different. We just keep going, we keep getting challenged, right? A topic that I've been extremely interested in is the idea of building a resilient and profitable business. And there's so many boxes that we could slowly check over a period of time. So this is just one aspect of that I wanted to discuss today, which is intellectual property and trademark. Our discussion today is going to affect your profitability and our future exit strategy. And so, let's go. Let's go. Good morning, everyone. So, intellectual property, and I'll tell you, for a while, I was not really getting exactly what that meant. It's like, well, I've done my trademarks, so what difference does it make? Today, we're going to have on our show today Dan Shulman, intellectual property attorney, shareholder of Vedder Price. And he's going to share with us. Dan, thank you so much for being on the show today.
Thank you so much for having me.
I'm excited. This is one that, thank you for having the time to sit down with me and go through it. We did a one-to-one with each other. And once you went deep on it, I realized I thought I knew some things. I did not know anything. So before we go into it, though, can you tell me a bit more about yourself and your company?
Sure. I'm a shareholder at Vedder Price, which is about a 300-person law firm, about 200 of them in Chicago. I'm in the intellectual property practice, which means I do intellectual property for a living. I spent about half my career as an in-house lawyer for a multi-billion-dollar company. If you ever used Reynolds Wrap or Hefty bags, you would know them. If you ever drink a Starbucks coffee, you probably drink out of their cups. If you ever got a container of strawberries at the grocery store, you ate the strawberries out of those plastic containers that my company made. So learn how to do intellectual property in the corporate environment, where I really influenced how I thought about strategy around intellectual property and bring that to my clients now in private practice.
I love that you said strategy. Let's jump right into it then and explain to me the difference between intellectual property and trademark so that the guests can have some starting point with us.
Yeah, sure. So trademark is one variety of intellectual property. So the important thing to keep in mind when you're talking about intellectual property, it is all about how you create exclusivity around the thing that makes you different, whatever that is. Every company does something different than their competitors, because if they didn't, you'd have no reason for a customer to buy your products or services unless you just drop price. And that's, you could do that, but it's not a great sustainable way to be in business. So you have to offer something different. Um, how do you stay different? Make sure other people don't do what you're doing. You build that exclusivity. Intellectual property is the generic term for the tools that people like me use to give you exclusivity. When you talk about who you are, the impression that your customers have of you, your brand, right? These are all things that, Paula, that you understand in the context of brand. That's a trademark. What does it mean from an intellectual property standpoint? Why is it a variety of intellectual property? Because nobody can use your brand if you have those rights. Nobody can say, I am XYZ if you've already got rights to XYZ, that XYZ being your trademark.
Well, let me a question that I wanted to pose later, but you just teed it up for me. Can you give me, I heard you share some of the clients like Starbucks, strawberries. Um, Give us some more examples. Explain to folks really what that means and what you were sharing. You know, because I'm listening to Dan speak, but I don't think I really have an intellectual property to really share. Um, Give us some examples of what does that mean exactly?
Sure. So the minute I said Starbucks, what came to mind to you?
The cup, the cup and the logo on it.
Right.
Yeah.
So you had it evoked a mental image and a feeling, probably,
Mm, yeah.
just based on me giving you a distinctive brand that nobody else uses, and that immediately evoked a business. When I
Mm.
said Reynolds wrap, what came to mind?
Tin foil.
When I
A
right when I said hefty, what came to mind?
strong bag.
So
Yeah.
there's your value of your trademark,
Yeah.
right? And that's why that trademark, once you have it and you have rights, is invaluable.
Mm.
You don't when you're Starbucks, you are developing a relationship with your customer, whether it's Reynolds Wrap, whether it's Hefty, whether it's McDonald's, whether it's Target, Walmart, IBM, Microsoft, you name it. You are developing a relationship with your customers. I can say to you, hey, look, I'm a big software company based in the Pacific Northwest. I make the tools that you use on your web browser and blah, 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 blah. Or I could just say I'm Microsoft. And how's best for me to communicate to you who I am that immediately evokes that relationship? It's to use my trademarks, it's to use my branding, right? Um, and if nobody else can do that, then now I've got an exclusive relationship with you that nobody else can impinge on.
No, you're absolutely right about that because every now and again I'll be in other places and the cup will have a logo on it that kind of looks like a Starbucks cup, and without thinking about it, you really kind of go there on no, wait a second, I'm not in Starbucks. It's not a Starbucks cup. They just made a cup that kind of infringes a little bit, but it did evoke that same comfort level, right?
Right. And that's what a trademark is supposed to do. And that's why it's really valuable and important for a trademark owner to say, no, you can't use my trademark because I want that exclusive relationship. We're in a relationship. If you're my customer, you're in a relationship. And like most adult relationships, I'd like it to be exclusive. Um, that's better for me. It's better for you. If somebody else uses my goodwill to be in a relationship with you and then provides services that are shoddy, a product that's shoddy, that reflects poorly on me. So my trademark and protecting that trademark is critical to me having that relationship, that valuable relationship with your customers. If you've got a valuable relationship with your clients, what are the things you can do? Charge a higher price because they're in demand for that, and grow your market share because people want the thing that makes them feel comfortable. If you can't raise your price or grow market share, you've got to wonder, well, why am I in business, right? Because those are
Yeah,
sort of the two growth strategies. So when you
exactly.
talked about at the opening, Paula, about we're going to help you grow your profitability, that's where intellectual property fits in, creating that exclusivity.
Well, let me ask you a question then. When is the right time to consider intellectual property for your business? Can you do it at the start, the mid? Like, when would be that time to start really looking at this or having a conversation with you?
Like 8 o'clock in the morning. Uh, so there's it's always time to do it. The question is, are you too late or right on time, right? Because it's almost never too early. And the reason I say that goes back to this thing, and we'll come back to this because I keep repeating it. Um, you have to do something different than your competitors, or at least
Yeah,
do something in a different way.
absolutely.
So from the very beginning, when you have in your head the first nugget, the first seed of an idea of what your business is going to be, I guarantee you it's different. Nobody thinks I'm going to start a business and do exactly the same thing as what's already out there exactly the same way, right?
Absolutely.
You have an idea, right? The minute you have that idea that you've got something different, you should start thinking about different means exclusive,
Yeah.
because the minute it's not exclusive anymore, it's not different. So the
Mm.
minute you have that idea is the time to start thinking about intellectual property.
Oh man. I mean, you're saying this and it makes me think of like a case study that I had literally yesterday. where a client we're coming in for the branding strategy, but they're in such a rush to get out and get in front of the investors, and we got to do it, we got to do it. It's like, okay, even you're in love with the name, but let's just take a look at is there anyone already ahead of you
Hmm.
with a name that might create a conflict somehow
Right.
to your name. And of course, once the client finally, after all the rush and all the push, it's like, okay, we'll get started because we know what you need to do,
Yep.
Now he's focused on it. Like, but like you said, it's never a bad time to start. At least we're still pretty early in the game as
Right.
opposed to 10 years from now. I mean, it's only like a month and a half into the process. So best time to catch it, I think, is as early as possible, for on the trademark side before you invest all that money in to start building the brand on the marketing end, and then
Absolutely.
realize that you may have to change your name, and just about everything. So, yeah.
Absolutely. That what you bring up is so critical from a trademark standpoint. Like the first step is you've got to do what we in the business call clearing your trademark. You have to make sure, as you said, that nobody else is using it or using something similar, right? And you have two concerns if you don't have a distinctive brand, right? One is you could be infringing on somebody else's mark, which is no good because somebody else can make you stop. We all know, especially for small companies, that your margin for error is so small. And if you have to brand and then immediately rebrand, you might
Yeah,
not recover, right?
exactly.
And so you really have to think about, I want to make sure that I'm able to do this without a hiccup. The launch has to be flawless. How many times do you hear from your clients, Paula? The launch has to be flawless, right? Well, there are certain things in your control, like clearing your trademark, that can at least remove that risk. The other thing is, even if you don't have a mark that somebody else wants to use, but it's not distinctive, right? So a client will come to you and say, I want to get a trademark on cereal. You're like, great. What product are you making? They're like, well, cereal. That's a really bad trademark, right? Because nobody will say, I just had cereal this morning, and they'll go, how was it? They go, it was great. You go, well, I'm going to go look for that. Where should I find it? You go, well, you go in the aisle in the grocery store that says cereal, and now you go and there's 200 different boxes, and you have no idea which one it was, right? It's a horrible trademark. Now you're just leaving it to chance whether or not the customer is actually going to buy the box of cereal that you want. So you have to choose a distinctive mark,
Yeah,
right? So the
absolutely.
second part of clearing it is not just the risk part, right? But it's do I have a brand that is actually going to serve me? So
Yeah,
that, because distinctiveness is important. Again, if you want exclusivity, you can't be like somebody else. You
yeah.
have to be distinctive. So a mark has to be distinctive. So you need to think about and exercise that creativity when it comes to identifying what's a valuable trademark.
Yeah, absolutely. And explain something to me, Dan,
Sure.
because I know that let's say you're a VC, and there's someone who has a trademark ahead of you that's
Mhm.
kind of close to the name, but they're in the financial end, maybe wealth management. That would create a conflict, wouldn't it? If your names are rather close to each other.
Well, it could. So have you heard of Apple Vacations?
Yeah.
Okay, so why are they able to use the word Apple? Because you think, what's the most valuable brand, the biggest computer, the biggest, company with the highest market cap in the world with more cash on hand than most countries? It's Apple. Why is there no confusion there?
Because it's travel versus computers.
Right. Nobody goes to buy a vacation and think, oh, this is also the company that did my iPod or iPad,
Yeah,
right?
yeah,
Or iPhone. Man, dating
yeah.
myself. Right. So there's no
I'll
confusion
tell
there.
you one,
If
Dan.
there's if there's no confusion, there's no trademark infringement, and you don't risk invading that exclusive relationship that you have with your customers because they're
Yeah,
not confused,
yeah,
right? So you can use the exact same trademark as somebody else if they're in a different market, completely different goods, different channel of trade, different sophistication of purchaser, right? All of those things are factors that courts in particular will look at to say whether is there trademark infringement, meaning is there a likelihood of confusion. So it's not just the mark name, although that can be important. There are some marks that are so famous that you can't really use them for anything. But for the most part, you can use the same mark as long as there's no confusion. And one of the things that I do as a trademark lawyer when we do those searches, we go, okay, there's some similar marks. How far away is this industry? And how comfortable are we with the risk that this industry is far enough away that I could tell you, I think it's probably okay for you to use this mark.
So like you can't use like Kleenex corner groceries or something. It might be inappropriate.
Right. Well, no, because you buy Kleenex at the grocery store. So I'm not even sure that it's true that right now. If you want to say I'm in Kleenex aerospace, that might be okay. But again, Kleenex might fall in this very small category, and I don't want to get too deep into the weeds of a famous mark that has a little bit more protection than an ordinary run-of-the-mill, very strong trademark.
Yeah, exactly. So is this process expensive, Dan? And how long does it take for a company to go through this?
Yeah, so if we're just talking about clearing a mark, I'll tell you it's certainly not more expensive than rebranding. So that's always something to keep in mind. Look, the cost is probably in the low 4-digit range, right? You could do a search. You have an attorney spend an hour or so evaluating it and giving you the advice. That $1,000 to $2,000 is almost always money well spent.
Yeah. And what about from the intellectual property and how? Because the word that really perked my ear up earlier is strategy. So I'm hearing a whole discussion before you even roll in, and how long does that take?
So it's always an ongoing process.
Okay.
Right. So trademark, as I said, is just one branch of intellectual property.
Yeah.
You may not be in a very consumer facing industry, right, where brands matter. Branding might not matter as much to you depending on the industry that you're in. You might sell through a distributor network. You might sell a service that is very much a back office, but people hire you not because you've got a great trademark or a great logo or anything like that. So in that case, you've got a different kind of intellectual property that's probably serving to provide you exclusivity. Could be patent, could be trademark, could be copyright. In most cases, though, because most companies don't have patents, very few companies have any real valuable copyright. Software companies do. If you're a publisher, you would, right? If you're an artist, you would. And companies that don't have a very consumer-facing business don't have the types of trademark issues that, say, a big consumer brand would have. So you don't have all of those things. So what do you have that's intellectual property? You have trade secrets, you have know-how, you have the way that you do things that your competitors don't know, that if they did know, they'd be able to compete with you. So when you talk about strategies to protect your exclusivity, and this is really key from a strategy standpoint, is do the people in the business who are doing the innovating know that they're creating something valuable and know that that needs to be protected? And when I say protected, I'm thinking in particular about two things. One, protected in the sense of nobody outside the company knows it, right? Because that's critically important, right? Arguably the most valuable piece of intellectual property in the history of the world is the formula for Coca-Cola. There's no patents on it, right? Because you'd have to make it public. I would guess that there's not even one person in Coca-Cola that knows what the formula is. That there are individual people in procurement that know I have to buy this ingredient, but I don't know how much of this ingredient. There's the person who runs the mixing machines, but all I know is it comes out of this pipe, and I know something comes out of this pipe, but I don't know what it is. I don't know how much. I don't know the concentration. it's probably that nobody, except for maybe in a safe somewhere in a cave, knows what the actual formula is, right?
Yeah.
That is, and as long as nobody knows what the formula is, nobody can make a soft drink that tastes like Coke, right? Now, most trade secrets aren't that valuable or that well known, but the point is you have to protect it. You have to not let your competitors know how you're doing things that makes you so successful. The other part is when you go to your investors, when you go to sell off a company,
Mhm.
when you start to think about what are the assets that I have, and the assets are all know-how, right? All trade secrets. Are you able to identify those things? Can you say exactly what your trade secret is, or at least categorize it in a way that you could prove to an investor that if you needed to identify it, you could, right? That if you needed to identify the employee who, if that employee left or got hit by the proverbial bus that goes around running over really important people, that you'd be able to recreate that knowledge. And so protecting your intellectual property also means creating that culture in your company. People say, I've thought of something. I'm not going to keep it to myself. I'm going to report it internally the appropriate way so that the company knows about it. Now we can all use it and benefit from it. So there's a lot of strategy around converting that innovation into intellectual property.
And also protecting it as well. I mean, because that to me is the biggest, that would be a big challenge if you're trying to protect it, right? So we now have the process, we're protected, but I love that you it goes deeper than that because
Mhm.
there's a whole strategy. Because what if that person gets hit by a bus? I mean, God forbid, but
Right.
and all that goes with them, how is that maintained? You know? Can you provide some examples of other infringements, or actually, even better, some consequences to that? So, if a company
Yeah.
attempts to infringe on your intellectual property or your trademark, um, what happens next? How can I protect myself? I mean, I have the
Sure.
paperwork, but
Yeah. So there's generally two kinds of things that happen if there's an intellectual property infringement. One is you get an order from a court to stop infringing. The second, and these are not alternatives, these often go together, is you pay me for the damage that you've done by your infringement.
oh wow, okay, yeah.
So, um, depending on the nature of the infringement, the damages could be small because you might be more worried about it's not the money that you cost me, it's the fact that you are damaging my goodwill with your trademark. So, in trademark infringement, you could have very large damages, including um, disgorging all of the infringer's profits from the sale, which can be huge. But often, what you want is just stop because my goodwill is invaluable and I just need you to stop.
Yeah.
In other cases, the damages could be hundreds of millions, $1 billion. There have been cases, especially patent cases, where the damages have been 9 figures, 10 figures. Most cases, the damages are not that big, but they're big enough.
Yeah.
High 6 figures, 7, 8 figure damage awards for infringement. So again, it makes the clearance process and that risk process really important to get an IP lawyer involved early. Um, some of the things that, just to give you an example of what a trademark infringement looks like, I'll give you two examples. Have you seen Coming to America?
Mhm.
Okay, so why is the fast food restaurant that John Amos's character owns? Why is that funny?
And I love that he's convinced it's not the same.
Convinced it's not the same, right?
What
But
was it? Not the golden arches, it was the golden something else. It's not
right,
the
it
same.
was it
Not.
wasn't it was the we don't infringe the McFlurry because we put the Oreos on the bottom instead of the top, right? Right. Why is McDowell's, funny, right? It's because anybody in their right mind immediately evokes McDonald's, right?
Exactly.
And the idea that the McDonald's people keep showing up and he has to chase them away with a broom. Now in real life, okay, McDowell's would have been gone. McDonald's would have put them out of business. They would have sued them into oblivion. They would have shut them down, right? Why? Because he's clearly trading on the McDonald's goodwill, right? That's the joke. Okay,
Yeah, yeah.
that's
Yeah.
what trademark infringement in its most
Well,
classical form looks like.
let me ask you a question though. All right, as you're growing your business, you've gotten to a really great stage of development
Mhm.
and brand awareness. How do you protect yourself internationally? I mean, really, I think we've been that way for a while, but COVID really moved that needle. We
Yeah.
are truly an international business environment. How do you protect yourself in other countries from the McDowells doing
Right.
something in like Nigeria or something? Like how do you
So
protect yourself?
so it's a really good question. The general rule of thumb, copyrights are a little bit different because there's a whole treaty around copyright. So I'm gonna set
Yeah.
that aside for a minute. Um, in general, intellectual property laws only apply country by country. So if you
Oh,
have a patent or a trademark in the United States, that gives you no ability to enforce it in, say, Canada, Mexico, England, Germany, Nigeria, unless you file and receive that patent or trademark
oh
protection
wow. Okay.
in those countries. Now, there are treaties that allow you to file based on your US filings, and sometimes if you don't file, you give up those rights forever. Depends on the nature of the intellectual property. But in general, um, you have to have a right to protect in the country that you want to go enforce. So if you are building this wonderful brand in the United States and somebody in Nigeria builds that exact same business with the exact same brand and they were there first,
Mm,
you don't really have an interest to protect. Why?
wow.
Because it's all about that likelihood of confusion. If nobody in Nigeria knew who you were, you don't have any rights to protect. You're the one now, if you go in, who's going to be confused with the earlier person. So,
Okay.
so what you do with your trademark rights internationally when it comes time to, for example, file for your trademarks. And by the way, this is important when it comes to trademarks in particular. You don't need to file your trademark with the trademark office, right?
Oh,
People talk about trademark as if it's a verb, right? I have to trademark this. Trademark is a noun. Trademark is a brand. Trademark rights arise the minute that consumer makes the association. So the reason why you file it is it gives you certain additional rights and helps you with enforcement, but you still have rights the minute that you use that trademark and start to build that association. So in foreign countries, if you haven't filed and you haven't used, nobody's building that association with you. You don't have any rights to enforce. So part of what you do as you build out your trademark strategy and your filing strategies as you think about, well, what countries am I going into? What
oh yeah.
countries are my consumers possibly going to encounter my mark? So you might not do business in Canada, but you might have a business in Buffalo and Maine and Minnesota. And even though you're not doing business in Canada, you have Canadian people that are coming in or that are just over the border that are encountering your mark, and you can't go sue them in Canada, but the minute they come into the US, you can do something about it.
There's something there. Okay. All right, so to wrap, this is one of those discussions that can go really deep. And like I said, the word strategy for me was everything
Yeah.
because, of course, I'm thinking verb. Thank you for that analogy, by the way. Just going in, speaking to Dan, let's get it done, let's get it started. Boom, we're
Yeah.
done, right? But this sounds like it's a long-term relationship, a continuing process, and really one where we need to sit down. Like I love that you said, let's look at where our target audiences are in the world, if necessary, based on our business model, and where should we be filing to protect ourselves internationally, right?
Mhm.
So, yeah, I wasn't sure if there was an international filing versus national. So that was an interesting one. What about,
There are Paula, real quickly, there are, especially for patents,
yeah.
and there are to some degree for trademarks. It's
Oh, okay.
regional. Um, it would be an advanced placement class on patent and trademark filing to get into it here. So the best thing I would say is call your IP attorney when it's time, and walk through those different options.
Call Dan. Call
Well,
Dan.
Dan, there you go.
What advice would you give to a small business owner that they they've heard the show today, they want more information. I really have some processes that I should be protecting.
Mhm.
Um, where would you tell them is the best place to start?
Well, a great introductory strategy call with me is a good place to start because I can walk you through with a questionnaire that I use with clients to really identify, all right, what is your innovation? Where is it being housed? Where is it coming from? And now let's build a strategy around that, right? For any company, um, especially if you're starting off, the questions that you should be asking yourself are, what am I doing differently than my competitors? Either the product is different or the way I'm doing it is different. And how do I make sure that that stays exclusive? And once you get your arms around the fact that that is a critical existential question for your business, you're ready to sit down with an intellectual property lawyer and now develop a strategy around, let's do it, right? I bring you the tools to turn your innovation exclusive. I don't bring you your innovation. You bring me your innovation, right?
Yeah. And Dan, if the viewers want to reach out to you for that conversation, what's the best way to get in touch with you? Go to the website, LinkedIn. What's your preference?
So LinkedIn is great. I am an avid LinkedIn user. I monitor my messages. LinkedIn, connect with me. That's great. You can go to the Vedder Price website, which is VEDDER price.com. You can find me there. You can find my email address. You can find my phone number. So call me, email me, LinkedIn messages. I have a tin can on a string. If you have the other end of it, I'm not sure where it is. It's very long. I can't see where it is. But if you have the other end of it, scream into it and I'll answer.
Did they file an intellectual property to like
On the tin can
make
with the string,
yeah, make
it
sure that
was
that's protected?
yeah,
I don't know.
yes. I think Tom did, and then Jerry infringed, and it
I
hasn't been,
heard
and
that.
now and then all the cartoon characters started
Yeah,
to.
you're right about that. I
Yeah,
forgot that big case in
the
the
big case.
cartoon newspaper
Tom
wires.
beat Jerry. Yeah, exactly. That's right.
So, guys, as always, thank you so much, Dan, for being on the show.
You're welcome.
If you are ready for this journey, please reach out to Dan. Have a conversation doesn't cost anything, and I know a lot of you get leery about looking at your financial structure bolstering up this way, but sit down and speak to these specializations like Dan for a conversation. And if you're ready for marketing, because part of your step would be marketing as well, please reach out to me at our website. My continued mission statement is to introduce you to what I call everyday experts and business owners so that they can offer their expertise and just expose you to an area that you may not be familiar with that could be massively helpful to your business. And of course, for marketing as well, where we help you to up level as well. So 10 to 10 airs every Thursday at 10 a.m. live. This is not pre-recorded and pretty. It's live on LinkedIn. So reach out and if you're popping in, pop into my page. You'll see it in my header. That's where the live screen will be rolling. Thank you so much, viewers, for supporting me. I can't believe it's been going since 2017. We started on Facebook. We're now here. And I really appreciate you guys so much. Our quote today, actually, to close out the show, I'm going to throw it over to Dan really quickly because actually it's Dan. So what's the quote that we wanted to close out the show today with?
Yeah, there's no overcoming without confrontation.
I love it.
So it doesn't have to be militant, but you have to confront conflict and confront challenges in order to overcome them.
And I
So
think that's true for so much in our
mhm.
lives, our businesses as well. There's always going to be that wall that you have to go through. There's no pretty way sometimes of going around it, right? Thank you so much for that great quote. And as always, thank you, viewers. Take care and have a great rest of the day.
Thank you.